So we completed criminal in the last week, save for two things that we didn't talk about. The first one is the specialized courts, and then we also need to have a discussion on judicial review, which I will just explain in this class. It's not something huge. It's just the normal judicial review that we do in civil as well. So I do not know. Maybe I will pick three people, or rather four people, to give us each one of the topics that they feel like they are not really ready around it. They don't understand it. And if that topic was to be set in question one, which is compulsory, they will not be able to answer that question. Okay. So that is um, criminal. So anybody that wants to volunteer, give us a topic. And that is four people. Now,
Good day, Malimo, and good day, everybody. Perhaps we could go through judicial review.
I've said I'm going to do that right now. So accept
Okay.
that.
Okay, that
Mhm.
was my area of concern.
All right. So that is Omwenga. With you now.
Extraditions.
Extradition. We did extradition in the last class. That is the last previous class. You still not okay with that. So that is extradition. Apart from extradition, let's go to Evanson. And lastly, to yes.
Appeals and inquests. I think we can retake it again. We did it in the last class. But, if you may, you can take us through some time. Thank you.
All right. Lastly, to Juan.
If we can go through just a summary of ID parade.
What do you mean a summary of ID parade? All right.
Some
All right. So.
Mm.
So we shall look at that. We shall look at all those things that you guys have highlighted. Let me try and see whether I can bring up my my screen. All right. After that, now anybody that has a question on anything, you can please put up your hand, and then we can take the questions. All right, Evanson, you have a question?
Sorry, that's an old hand. We can proceed.
All right. All right. So let's start. If there's no question, I want somebody to start again. We start from this exact point we start every time, and that is the question to do with the criminal procedure, because that is where the issue is. That is where the issue is. So somebody to take us through the criminal procedure. This is almost the 15th time we are talking about the criminal procedure. Yeah, but it is very important because you will not pass this exam without understanding the criminal procedure. You cannot even try to imagine passing this exam without criminal procedure. And sadly, criminal is one of the units that are very sensitive in terms of procedure. What is set, it is purely procedural. Okay, there are not so much of drafting in criminal. Yes, there will be drafting, but not so much as would be in civil. And that therefore means that most of the things you will be doing will be around advising somebody or giving an opinion on a given matter, whether it be drafting a ruling or giving a legal opinion or advising. So that will be the nature of the criminal paper. Now, the first thing and the easiest thing that you want to do is to um, master the process, and that process is the criminal procedure. So we can start with somebody to give us what they understand the criminal procedure to be, and then we can proceed and look at our discussion for today. And if this is your first time um, understanding or going through the criminal procedure, please pay attention, make some notes, and then we are on the same page. Somebody who wants to take us through that process again? All right, so let's go to Penina. So just the summary of the process.
Yes,
And
Mwalimu.
wait, before Penina. Penina has given us this process every single class. She has given us this procedure every single class. Guys, can somebody else give us that process? Because it's always Penina giving us the procedure. Somebody. Let's go to Omwenga. Yes, Mora.
We start with the complaint that is made. After the complaint, we go to the investigation.
Hey. You know I don't like those answers. Complaint is made to who? What are you saying?
A complaint is made to the police. After the complaint has been made, investigation commences, and under investigation, three things happen. That is an arrest, an ID parade, and preparation of the files. Yeah. Yes, after preparation of the files, the file is then forwarded to the DPP, and the DPP has powers to determine whether to pass charges, whether to
Hey, what do you mean pass charges? What is passing charges?
whether the DPP decides whether to charge or not to charge. And if the
Under
DPP,
what law gives the DPP that power?
Article 157 of the Constitution.
Okay.
If the DPP decides to charge, then the accused person is arraigned in court. After the accused person is arraigned in court, charges are read to him, and then the accused pleads to the charges. He can either plead guilty, not guilty, presidential pardon, to for convict, or to for what convict? Discharge.
What is that you're saying? What are those you're saying?
After pleading, and then the accused person is admitted to bail.
What are the pleas? What are the pleas? What are the pleas?
Plea of guilt, plea of not guilt, presidential pardon, to for convict, or to for acquit, or can remain silent. And if the accused pleads guilty, he is admitted to bail. After bail, then the trial process now begins. We go to the pre-trial.
What happens before the trial process? Hey, what happens before the trial process? Somebody else speak from there. Rachel?
So before, sorry, can I just start a step behind so that I can have a mental flow?
Yeah, okay, proceed.
Okay, so after the accused person takes plea, or after plea taking, there are some things that happen, like the accused person there's some considerations that happen in court. For example, does the accused person have representation? Do they understand the language of the court? And also a mental assessment. After that, we go to bail and bond, under the bail and bond policy. And of course, immediately after bail and bond, we go to pre-trial, if I'm not wrong. After pre-trial, we go to the trial and the process of trial. And after which we will have a judgment.
What is the trial process?
Okay, so for the trial process, first we will have the prosecution, who will of course have an opening statement. They'll bring their witnesses, and then after that, the court will determine whether the accused has a case to answer. If the accused does have a case to answer, then they will be put on their defense, and then they can have the opening statement, bring their witnesses, examine them, and have those witnesses cross-examined by the prosecution. And then after that, we move now to the judgment. And the judgment is usually just a declaration of guilty or not guilty. And then if they're guilty, they are convicted and we move to sentencing. If they're not guilty, they will be acquitted. Yes. After, do I move on to after sentencing? After sentencing, there are things that can happen. We can have either an appeal. This is now by the accused person, or even by the state. Or by the state, I mean by the prosecution. We can have an appeal, retrial, or revision.
All right. So that is clear, guys. So guys, you want to try first and go through the criminal procedure. You want to try first and go through the criminal procedure. That is the first thing that you want to do. Before you read anything, please, I'm begging you, make sure you know the criminal procedure. If you do not know the criminal procedure, then you have a very long way to go in terms of criminal, because you can't cram specific units or topics. You can't cram them. You just need to understand them. And if you understand them clearly, it is easy for you to navigate. What am I saying? I'm saying if you understand the process from the very beginning, then if a question is set, because questions will always be set on a specific aspect of the procedure, you will be able to know that this question is about plea, or it is being set at a point where this person is supposed to take the plea, and therefore, what are the procedures around plea? If it is about trial, what is it that is required under trial? You get the point? So please take your time. Take your time and go through the criminal procedure. I'm going to go through it again, but before then, I want you to please make sure you understand what it entails on your own. All right. So I hope that is clear. So please let's get into the discussion today. So I want us to start from the specialized courts, and then we go to judicial review, and then we can start from the very beginning, or entertain questions from the very beginning. Throughout our discussion, we've revised. There is no single topic that we have done that we haven't seen a past paper on. We've gone through a lot of past papers through our discussion that we've had on and on again. So please also make sure that that is clear. Also make sure that you're keeping tab of whatever we have discussed and read as wide as possible. Tianga, you have a question?
Yes, Mwalimu. It's not a question per se. It's not a question. Please allow me to take you back when you had requested us to tell you the topics that we'd like you to go through. I wasn't able to in my system.
You can't. That is closed. Please, let's move forward. Mute your microphone, please. We are past that. Now let's go through the criminal the aspects. Stop breathing and mute your microphone. Let's go through the specialized courts. That is the first one, and then we can go through the judicial review, and then we can go straight into the discussion that I want us to have, which is from the very beginning to the very last things, entertaining the key nitty-gritties around each and every topic. But criminal is very easy, guys. You can even sit in your house and just predict what CL is going to set. You can even sit in your house and do that. So please, make sure that you're doing the revision. You will be fine. You will be fine. Trust me. All right. So let's go through what we have today. The specialized courts. So within the criminal justice system, okay, we have institutions that have been put in place to entertain certain disputes. We have institutions that have been put in place to entertain certain disputes. Okay, which are these institutions? We have the courts. Okay, the court of law, that is from the magistrate court to the subordinate courts, magistrate courts, and then we have the High Court and the Court of Appeal and the Supreme Court. And then we also have certain quasi-judicial tribunals that may entertain several aspects that may lead to a criminal trial, as well as we have now the administrative institutions such as the DPP, such as the DCI, the IGO Police, the Ministry of Defense, the NIS, the EACC, the NCIC. All those are criminal institutions that are mandated within the law to entertain certain matters that are criminally linked. Are we together? Now, in terms of specialized courts, there are certain matters that are being given specifically to the specialized courts. Are we together? Now, the first one is the Children's Court. The Children's Court is a specialized court. This court is a court that is created specifically to entertain questions to do with children, either in civil or in criminal. Are you together? So that is the the Children's Court. So anything that deals with children, that jurisdiction has been given specifically to the Children's Court. Guys, are we together? Give me 1 second. All right, sorry. So the Children's Court, which has been given jurisdiction to entertain matters dealing with children. Somebody's having the microphone on, please. Somebody's having the microphone on, please. Can you mute them? Somebody's still having the microphone on. Okay. So that is the Children's Court. And then we also have the Anti-Corruption Court. The Anti-Corruption Court is a court that is created specifically to entertain aspects to do with the anti-corruption, matters to do with corruption-related charges. That is also a court that has been created for that specific purpose. Apart from the Anti-Corruption Court, we also have, the court martial. the court martial, and also we have the county courts, that is the municipal courts, and we really don't have the traffic courts because within the system, yes, every court can entertain the traffic matters, okay, but there's a debate or a discussion to have a specific court that will just handle the questions to do with traffic. Just like we've seen the questions in, the Chief Justice creating the appeal system for the ELC, we might be able to see the law or the Chief Justice, not even the law, the Chief Justice creating a system whereby we have a specialized court system just for traffic matters. But because the judiciary is not properly funded, the judiciary is understaffed, we cannot have one single court that deals only with traffic matters. So we also have traffic courts, which of course in books it is supposed to be entertaining questions to do with traffic matters. And then I've talked about the municipal courts. I've talked about the court martial. I've talked about the children's court. So let's start from the children's court, which is the special court number 1. So when you talk about the children matters, there are certain things you need to understand. Okay, we have 2 categories of things. We have child accused person or accused people that are children, and then we have child witnesses. Okay, so when we went through the trial process from the very beginning to the last end, we made some specific considerations when it comes to children. Okay, so in any specific instance, a child in court could either be an accused person or could be a witness. Okay, a child can be an accused person or could be a witness. That is number 1. Number 2, you must understand who the child is. So of course, within the law, within the Children's Act of 2022, we have a child defined as any person that is below the age of 18. Okay, that is number 1. And then the jurisdiction in this matter is given specifically to the Children's Court. So the Children's Court, guys, is a special court. Even though we don't have a specific building in most instances, except for I think Mombasa and Nairobi, we don't have specific building that is called the Children's Court. Most of the time, the children's matters will be handled in the normal courts, but of course the court must reconstitute itself and make sure that that court from that moment is operating as a children's court. Number 2, the children's court are only manned by a specialized magistrates or magistrates that have been empowered by the Chief Justice to handle children matters. So not every magistrate will be handling, a matter dealing with a child or a matter where a child is involved as an accused person or even in civil. So that is clear. So you know the person who is a child, that is 18 years and below. Number 2, you understand the question to do with jurisdiction, where we're saying that jurisdiction to entertain or to hear and make decisions relating to children is left specifically for magistrates that have been empowered. Okay, magistrates that have been empowered to issue orders or to entertain such matters, and that is done by the Chief Justice. And then we have said that at any specific time, a child could be either as an accused person or as a witness. All right. The next thing that you need to understand is that sometimes, not every time a child will be prosecuted in the children's court. Not every time a child will be prosecuted in the children's court. And in this instance, there are several examples. Number 1, where the child has been accused alongside adults. If this child has been accused alongside adults, which are people of 18 years and above, then they will be tried in the normal court. But of course, even in that instance, the court must always take into consideration the best interest principle of the child. And then, of course, where the child has been accused of murder, of course, that is purely the High Court. Remember that the Children's Court is a subordinate court. The Children's Court is not a magistrate court. It is a subordinate court. That is what I need you to understand. we have the court structures. The first one, the very, very least court structure is the subordinate court. From the subordinate courts, now we come to the magistrate court. Okay, from the magistrate court, we go to the high court. So we have other subordinate courts apart from the magistrate court. So the children's court is not a magistrate court. It is manned by the magistrate, but it is not a magistrate. It is not within the rank of the within the classes of the magistrate court, the 5 classes. No, it is not. So we have the magistrate court, and then we have other courts that are subordinate as well, which are the children's court, the court martial, even the small claims court, the anti-corruption court, the county courts. All those are subordinate courts, but they are not magistrate courts. You will find magistrates sitting in those courts, but those are not magistrate courts. I hope that is clear. All right, so that is the question of jurisdiction. So what do you need to understand when it comes to the children's court, the procedures before the children's court? The first thing is that at all times where a child is an accused person, then the court must always take into account the best interest principle of the child. And that is all the way, guys, when you are mentioning the criminal procedure that Penina and not Penina, but Omwenga was giving us, when you mention the criminal procedure, at every instance, whether it is investigation, whether it is question of ID parade, arrest, charges, plea, bail, the court or the people that are in charge of that procedure must always give preferential treatment to children in line with Article 53. So if it is bail, the court must consider that a child should not be detained if there is an option of non-custodial, if there's a non-custodial option. For instance, when you're considering the facts as a court, either to deny or to give bail, one of the things that must be considered is the question to do with the age of the accused person. So where there's a child in question, they must be given a preferential treatment. And then the same will apply to even the question of plea. When you're taking a plea and the person in question is a child, then you must ensure, number one, they have an advocate. Children must always have an advocate. They must always have an advocate. That is a law that will not change. You must have an advocate as a child. Should be given an advocate because chances are you will not understand whatever you've been accused of. At the same time, we must also ensure that the child is of a sound mind, the child understands the language of the court. So those things the court must do as a matter of obligation. Okay? When it's the question to do with the hearing procedures for a child will be different from those of an adult. Okay, when it comes to the question of sentencing, judgment, let's come to judgment. The court must give, there's certain things that the court must do that the court ordinarily will not do when it comes to the trial of another. Sentences, certain sentences are not available when the accused person is a child. For instance, death penalty, life imprisonment, those are not available when you're dealing with a child, as well as imprisonment in an adult prison. Those are not available when it comes to a child. So every time you're dealing with a child, there's specific treatments that you must give a child. Are you together? So let's go and discuss the question of children who are in conflict with the law. Children who are in conflict with the law. Okay, so that is a child who has been convicted. So in the normal ordinary sense, you will, in fact, let's start from the very from behind so that we move systematically. The children in conflict with the law. Children in conflict with the law, what am I saying? I'm saying that at any point that a child has been arraigned before the court, at any point a child has been arraigned before the children's court, okay, as an accused person, there's certain things, even during the trial, there's certain things the court must do. The first one is the court must ensure that the environment is child-friendly. The environment is child-friendly. Now, if this child is a child of a tender age, the court must ensure that there is an intermediary that the child can testify or participate within the trial through an intermediary. And intermediaries are parents, guardians, counselors who will be, we have discussed intermediaries before, so make sure you understand intermediaries, as well as circumstantial evidence, because those are other special things that will come during a trial that you need just to understand. They may not be taught specifically in KSL, but you will have them at the back of your hand. That is intermediaries. We talked about intermediaries where I said that an intermediary is a person that is coming to court to give evidence or to assist a witness or even an accused person to give evidence. Okay, so who can be an intermediary? A parent, a guardian, a counselor, a teacher. Any person can be appointed as an intermediary to help in the giving of evidence by the person, the vulnerable person in question. So that is the first one. So if they are not able to understand, they're not able to speak up clearly or give the evidence smoothly because of their age, and this is a question of being of tender age, 12 years and 11 years, between 11 to 13 normally is a tender age. Then of course the court will have an intermediary. The court will have an intermediary, and this is both for accused and witnesses. All right, so we have also, as well as the court must ensure that the child understands the language of the court. If the child cannot understand the language of the court, again, the court will always offer a translator in that regard to proceed and translate whatever is being said to the child. So that is translation. Okay, and then during the examination of the child, of course, every court must ensure or must put in place, systems to ensure that the privacy and confidentiality of the child are protected. So the court must always be, the hearing must be either done in chambers or in camera. The court must be cleared. It means the media must be out of court. The general public should be out of court, because now it is the children's court. They need to protect the integrity of the child, as well as the his right to privacy and all that, as well as remember that the court documents should not reflect the actual name of the child. Okay, and then in terms of examination, when you are examining a child, of course, make sure that you are not badging, you are not being offensive, you are not pushing too much, you are not using offensive languages, you are not being too sensitive or mentioning or referring to matters that would be sensitive to the child at any instance. So that is the question of examination, as well as we have the trial within a trial. In an instance where the child is a witness or the child is tendering the witness before the court, the evidence before the court is supposed to conduct a trial within a trial, just to understand whether the child understands the seriousness of the business of the court, whether they understand the need to be truthful in their testimony. Okay, and this can be done through what you're calling questioning, where the court will be questioning the child on key matters, where they go to church, whether what they're taught in school, and this is because the court would want to understand whether the child understands the need to say the truth before they bring up their evidence. And then lastly is the question of sentencing and judgment and sentence. So where the child has been convicted, the court or the judgment cannot write the child is hereby convicted. That language is not available when the child the child is the one being convicted. When a child is convicted, you don't say the child is hereby convicted. No, that language is not available. Instead, you must indicate that the court has found the child to be in conflict with the law. The child to be in conflict with the law. So don't say a child is convicted. No, the child is found to be in conflict with the law. That is the conviction. Secondly, is the question of sentences. If you are sentencing a child, if a child is being sentenced, then you cannot use the word sentencing. You cannot say the child has been or is hereby sentenced to. No, you will indicate that the court makes a consequent order. The court makes a consequent order. Okay, for instance, if the child has been found to be guilty of stealing, the court will indicate that the child has been found to be in conflict of the law or in conflict with section 168 or 268 of the Penal Code. So they have been found to be guilty of that specific section or offense. And then you say, and the court makes a consequent order that the child be detained or the child or the court makes a consequent order of, let's say, probation, fine, whatever sentence the court would want to give in that circumstance. So you make a consequent order that is for sentences. And then still on sentences, like I've said, there are certain sentences that are not available when you are dealing with a child. When you're dealing with a child at any specific time, then you cannot sentence the child to death. That is one. Okay, you cannot sentence the child to death. Okay, number two, you cannot have the child for life. You cannot sentence the child to life imprisonment. That is not available as well. Children cannot be sentenced to death. They cannot be sentenced to life imprisonment. Number three, you cannot detain, you cannot jail a child, or you cannot send a child to an adult prison, or a child should not be detained with adults. So if a child has been found to be in conflict of the law and a consequent order has been made, the court must, number one, consider all non-custodial sentences first, and then if there is no non-custodial sentence in that instance, then the court will make an order of custodial sentence, but not in adult prison or adult detention center. So what are these custodial sentences available when you talk about children? The first one is Boston institutions. So Boston institutions are for children above the age of 15. So 15 years and above, you go to a Boston institution. If you are above the age of 15, you go to the Boston institution. Okay, if you're below the age of 15, you shall go to the rehabilitation centers. So if you are 14 years, you shall go to the rehabilitation center. When you turn the age of 15, you are transferred to the Boston institution in Kakamega. I think there's one in Kakamega. Another one should be, is there one in Nairobi? There's one in Mombasa, I think. I don't know if there's one in Nairobi. For those who've been who have seen, have you seen a Boston institution in Nairobi?
Yes, mwalimu. There's
Yes.
Kamai Boston in Kamiti.
Oh yeah. So yeah, so Boston institutions are for now the big children. So 15 years and above, up to 18, so up to 17, they go to Boston institutions. So if the child is below the age of 15, they will be taken to rehabilitation centers. Rehabilitation centers. If they grow, if they turn the age of 15, they are taken to the Boston institutions. Okay. So that is what is supposed to happen. That is what is supposed to happen. Okay. All right. So that is the question of children. The question of children. Again, the court must always give non-custodial sentences when it comes to children, except in the instance where it is not possible to give a non-custodial sentence. So we have the non-custodial sentences that we have. Number one, we have fines, community service, suspended sentences, probation, all those, anything that doesn't involve somebody going to prison or being detained, that is non-custodial. So children must always be given an option of non-custodial at any specific time. Okay, that is the question of children. So any question in terms of children? Any question in as far as children is concerned? Anthony? Jamal?
Okay, my question is with regards to representation of children. There was a time I attended a court session in Kwale, and there was a group of children who were being charged for breaking and stealing in a school that they were studying in. They stole laptops. So during plea taking, the magistrate went ahead and she was taking their plea until one of the advocates who was there for a different matter volunteered to represent them. So right now, when you say that children must always be accorded representation, I was wondering what would be the consequence of if that advocate had not volunteered to actually represent them pro bono. What will be the effect of that magistrate continuing with that trial? Because she was actually noting down whatever pleas the children were actually pleading to.
That specific order will be set aside. That specific order, in practice, is very fun. In practice, magistrates are very casual. You know, magistrates are very, very, and with tremendous respect, magistrates are not, they're very, very casual. And most of the time, they always say that if you don't agree, you can always appeal. That is usually the most argument that magistrates will give. They don't really care about a lot of things. They will just proceed and write very sketchy things. You know, you saw I think 2 years ago, where there were questions where I think a magistrate was being removed because of writing those things. First, they don't write well, and then sometimes they don't make, and that is why you have revision. That is why revision is there. So the child, even if you look at the case of Karisa Chengo, the Supreme Court case, one of the factors the court must consider is the age of the child, because that is where substantial injustice would occur under Article 52H. You need to give the child, an advocate. And in that instance where the child cannot afford that advocate, then that is where you get the pro bono. Any person should be given an advocate. If they can't afford, the court must give one at the expense of the state. So you must give the child, more so where a child has been accused of a sentence that is not a misdemeanor. Stealing is a felony. And therefore, if a magistrate proceeds and gives an order, makes an order that takes the plea, for instance, takes the plea, and then the hearing continues and the child has been convicted, that specific sentence and conviction will be set aside very easily, very, very easily. Okay, so that is one thing that that must be done at all times. If you are appearing in court and or maybe your son or your daughter or your friend who is a child has been accused of something, then make sure that they have an advocate. If they don't have an advocate, always make an application to have the High Court stop the proceedings and assign an advocate, because that is the right. The magistrates don't care. They want to complete the files. They want to, double down on the backlog and they move on. They don't really care about the welfare of the child. So that is one of the grounds that specific proceedings will be set aside because of the flaw in procedure. They need to be given an advocate. Whether they're the age of 18 and they have beards until their toes, they're still children. Okay? So please, they must be given an advocate. So long as you meet the definition of a child, you deserve to have an advocate. Are we together?
Yes, we are. Thank you.
All right. Any other questions? So the next one is a question of municipal courts. So not municipal courts, sorry. The court martial. The court martial is supposed to try offenses related to the members of the armed forces, the members of the armed forces. So that is the KDF. So this court martial is created under the former Armed Forces Act, which was repealed. Now we have the Kenya Defense Forces Act. So that is the Navy, the Army, and the Air Force. So members, any person that commits a crime within the KDF Act is supposed to be arraigned before the court martial, before the court martial. So tell me, which are the offenses that you think will be chargeable, quote unquote, before the court martial? What are these offenses? Somebody. What are these offenses that we're talking about? Tianga, Jennifer.
Desertion.
Yes, desertion. So you can't just come in and go. You can't just come in and go. As a member of the KDF, you don't just wake up and say, today I want to disappear. I don't want to be a member of the armed forces anymore. You don't just come in the way you come in. When you join, there are procedures of retiring from service. So you are not allowed to just walk in and walk out the way you want. Any other person? Jamal?
Acts of insubordination or mutiny.
Okay. Insubordination, they are discipline forces. So part of being discipline forces is that you have to obey the order from above. So that is where order from above will always be working. Anything else? Mithika?
Treason.
Treason.
Well, assisting the enemy or giving them classified information about your country. I don't know whether that's treason.
What do we call that? Yes, it is, but what do we call it? Yes, Tua John?
Espionage.
Yes, that is espionage. It's fine. That is espionage. So if you leak information, classified information to an enemy or unauthorized persons, that is espionage. So in all, those things, all those offenses that will be chargeable before the court martial, they relate to members of the armed forces. So the court martial is headed by a judge advocate. They're called a judge advocate, and they're not judges. They're either magistrates or an advocate of the High Court of Kenya. If the person is a magistrate, then of course the magistrate will be eligible to be appointed as the head of the court martial, as well as if you could be an advocate of Kenya, High Court of Kenya, you must have at least 10 years of professional experience practicing. Okay, so that is the member. That is what forms the head of the court martial. So when you look at the KDF Act, look at that act in as far as the court martial is concerned. I think that should be section 162, 160. From there, you'll find the court martial. So any appeal from the court martial, you go to the High Court. So I did mention any time you're appealing the decision of a children's court, then you have to go to the High Court. Okay, the same as the court martial. All right, that is clear. So I don't want us to talk about anti-corruption court, municipal courts. There's nothing special about them, or the traffic courts. Now, let me mention about something about the municipal courts. Municipal courts are the county courts. They are created specifically to entertain any breach of the county council regulations. The regulations that have been put in place by the county government. Each and every county government has got their own municipal laws or municipal rules. Where do you park? How do you do your things? You've seen that guy walking every time and closing down businesses that are making noise. That is within the county legislation. So any breach of county legislation, you will have them before. You will have them before the municipal courts. So again, the normal things that are created within the County Governments Act, within the county government legal framework, and that includes the example I've given. So the county government of Nairobi will have legislations including questions to do with parking, business permits, and all that. So if you're operating a business without permit, you will be arraigned before the municipal court, the county court, as they're called. And then, of course, they're headed by magistrates. Those courts are headed by magistrates, and any appeal from that decision goes straight to the High Court, just like a subordinate court. So the rest of courts, I don't think there's something special about those courts that we need to mention. They're just the normal courts that are headed by magistrates. Like I've said, we don't have traffic courts that have been specifically given that mandate to just handle traffic matters. And in most instances, even out of Nairobi, you'll find any person who has committed a traffic offense will be arraigned before the normal magistrate court. All right, so I want us to go to judicial review, but before we go to JR, I will take questions. Any question? Namoko? Namoko, we can't hear you. All right, any other question? No question. So judicial review. So in terms of judicial review, guys, there's really not much of something you need to understand about JR, but I'm going to explain in a minute. I'm going to explain within a minute. Sorry. All right, I'm going to explain that within a minute. Now, judicial review in criminal. Judicial review in criminal. You for sure may get a question 6. Judicial review questions are either 6 or 5. 6 or 1. Okay, you will have that either 6 or 1. Now, when it comes to judicial review in a criminal exam, what is it that you need to understand? What is it that you need to understand about judicial review? The first one is that judicial review is not criminal, neither is it civil. Judicial review is just judicial review. Judicial review is not civil, neither is it criminal. Judicial review is just judicial review. Okay? Judicial review is just judicial review. Number 1. Number 2, judicial review is not a document. I've been saying that over and over and over again. Judicial review is not a document. And what is the meaning of that? It simply means that when it comes to judicial review, we are not making reference to a specific document. Judicial review is a remedy. Okay? Judicial review is a remedy. When I say judicial review is a remedy, what I mean is this. Okay? You can go to court and get a remedy of judicial review. So it is a remedy to remedy something. What other remedies do you know? Number one, you know damages, you know injunctions, you know conservatory orders, you know a declaration of right or a declaration of invalidity of law. So you know those remedies. Okay? Now, judicial review is part of them, so that there are certain instances you can go to court and tell the court that this specific institution or this specific administrative institute or body has done something that violates my constitutional right or that violates my Article 47. Like I've said, guys, I took a lot of time in civil explaining the history of judicial review, explaining how we got to Article 47 and how we got to Article 23, 3F, all the way from Marbury versus Madison through Section 89 of the Law Reform Act, Order 53 of the Civil Procedure Rules, and finally, Article 47 of the Constitution, as well as Article 233F. Okay, so judicial review is judicial review. Whether you are taking it in criminal or you are taking it in civil, you will give the same advice and you will draft the same documents. Okay, that is number one. Number two, judicial review, like I've said, is not criminal or civil. It means you don't take judicial review to a criminal court. At the same time, you don't take judicial review to a civil court. Judicial review goes to a JR court, which is the High Court. So when you file a judicial review application, it is a judicial review application number this. To the High Court, judicial review application number this. It is not civil application number this. It is not criminal application number this. Judicial review is neither criminal nor civil. It is just judicial review. Tunaelewana? Now, when do you I'm trying to get a question so that I can explain judicial review in criminal using that question. So 2019 question 1 or 20 November 2021. Let me see if I can get 2021. Question 1. Question 6, sorry. Downloads. Where are my downloads? Let's say November 2021, question 6. If it has a question on judicial review, should, so that we can read that question, and then I can explain judicial review, and we understand. Allah, which paper is this I'm looking at? I want civil. Criminal paper. That's, if you have a question, guys, ask as I move down this as I move down to the question that I'm looking for. Anybody with a question, this is your time to ask. Was there no question in this year? There should be one. Oh, there's criminal there. Let's see question. No, it's 2021. You. All right, give me 1 second, guys. I'm trying to get down to that paper. In 1 minute or 1 second, I'll be there. Question 6 should be it. Madeline, yes. Question 6. That is, let me bring up my screen. Right there. You can see my screen.
Yes, we can.
All right. All right. So that is a question on judicial review. That is a question on judicial review in criminal. Now, let me explain judicial review. So I've said, guys, judicial review happens at any time when you feel that you are right under Article 47, or really the rules of natural justice, have been violated. That somebody has violated your rules of natural justice. And what are these rules? When you look at Article 47, it provides for instances where, okay, guys, let's make it clear. Instances where, when a decision has been made, certain things that must be adhered to. Number one, it must be a fair decision. It must be reasonable. The person must receive notice. The person must receive notice. They must have the reasons why that decision has been made. They must be given an opportunity to defend themselves. They must also be given an opportunity of appealing that specific decision. So it comes from administrative decision. It must be an administrative decision. That is the second thing about judicial review that you must appreciate and understand. Okay. The next thing about judicial review that you must understand is that anytime judicial review is being set, okay, anytime judicial review is being set, anytime the examiner is bringing you a question on judicial review, number one, Article 47 has been violated, and therefore the rules of natural justice have been violated. And anytime that decision has been made, the person affected by that decision has not been accorded any opportunity as indicated in the rules of natural justice as well as Article 47. So Article 47 is the one that coins the rules of natural justice. Now, the next thing is, how then do you go to court? Before we go to court, remember that this judicial review is only available against administrative institutions, institutions that make administrative decisions. These are institutions that make administrative decisions, not courts. You cannot challenge a court decision through judicial review. However, you can get a judicial review against or directing a court to do something. Guys, you cannot challenge a court decision through judicial review. However, you can get an order of mandamus, for instance, directing a court to do something. Let me explain. And we'll explain using this example. So how then do you go to court for an order of judicial review? There are two ways you go to court. The first way is through a judicial review application. That is a JR application that we have done in this class a lot of times. The second way is through a petition. Okay? The second way is through a petition. So which one would you prefer? If the question provides that you draft a pleading, just like the question that we have here, just draft a petition. If the question say draft the pleadings, draft the petition. However, you can still draft the JR application. You can still draft the JR application. The danger is you will waste time. You will waste a lot of time. You will draft a lot of documents that you could have avoided if you just did an a pleading. So when you're told to prepare the pleadings, then the examiner opens the door for you either to do a petition or to go the usual way of an application. If the question say prepare the application, then it is an application. Okay. Number three, if the question say proceed and file the substantive document, it means you do the notice of motion only. If the question was to say proceed and seek leave, then you seek leave only. If you're told leave has been sought, you do the substantive application only. So it is within the last word. Draft what? What are you drafting? Let me get 2019 question. 2019 question. There's a question in 2022. Question 6 as well. It should be question 6. Now, anytime the question say prepare the pleadings, then what are you supposed to prepare? Now, there are two ways of doing that. Either you can decide to go through the usual process of judicial review, because judicial review, I've said, is just judicial review. There are only two ways you can get it, through the JR application or through the petition. So if the question was to tell you to prepare the pleadings or you are supposed to prepare the appropriate documents, then you can either do the petition itself, which would be the appropriate for to do in that instance, or you can do the JR application, which are the 5 documents. You will still not lose your marks, but you will lose time. If the question was to be very specific, because remember, sometimes in criminal, and I'm saying this in criminal, sometimes in criminal, the examiner would want to use the word pleadings and applications interchangeably, or the examiner would want to use the word pleadings. You know, pleadings are not specific. Guys, pleadings are not specific. Application is specific. If the question say draft an application, then it is an application. But if the question say pleading, sometimes examiner and people have used the word pleadings to mean a lot of things, including the substantive miscellaneous applications. Okay, so the miscellaneous applications have also been viewed as pleadings. Let me explain that again. Let me take it again so that we are at home. Pleadings, we know the types of pleadings that we have. Okay, we know that the types of pleading that we have: petition, plaint, statement of claim, originating summon. These are the main pleadings that we have, and we have the memorandum of appeal, petition of appeal. Those are pleadings, the main pleadings that we have. So anytime the examiner says prepare the pleading, you need to be thinking of the documents that I've just said. However, there is another type of pleading which is really not a pleading, but it is regarded as a pleading, which is a miscellaneous application. Why is it regarded as a pleading? It is regarded as a pleading because normally applications cannot stand on their own. Only pleadings can stand on their own, but miscellaneous applications can stand on their own. And because they can be able to stand on their own, sometimes the examiner would want you to, or would refer to them as pleadings as well. And what are these miscellaneous applications that you're going to meet most of the time in your practice or in your exam? Number one is a judicial review application. It is a miscellaneous application. You could also find habeas corpus, an application for habeas corpus, which is a miscellaneous application as well, and therefore the examiner would want to call it, a pleading, which it is not. And sometimes also you could find a retrial, but retrial is not a miscellaneous application. Retrial is an application, and therefore you leave it at an application, except in the instance where the examiner would want you to go through it using a petition as well. But I will explain that later. Now, so anytime the examiner is saying you draft the pleading, then you draft the main pleadings that we know, but also if there is a miscellaneous application in that specific angle, which is this question now, then you proceed and do that. So you could do either. I will say that again. In the question that we have read, there are two ways of getting it. There's one way, which is a miscellaneous application, which is regarded as a pleading, quote unquote, and then now we have the main pleading, which is a petition. Okay. Now, how do you approach the court? You can approach the court either way, which is the pleading itself or the application. But if the question was to say prepare the application, then you can't prepare a pleading. You can't prepare a pleading. Application is more specific that it must be an application, either a chamber summon, a notice of motion, or an originating summon. Those are the only applications that we have in this world. Everywhere you go to India, Israel, they are just those applications. Okay? Everywhere. Okay? Now, if the question was to say pleadings, then it opens the door. First, the main pleadings, and then you could also consider the miscellaneous pleadings. Now, in that instance, the notice of the application for judicial review. So that is clear, guys. Am I clear? Am I clear? I will try and get another question to explain. Mwanga?
I'm just being curious. At what point can one lose a right to bring a JR?
Where?
When your constitutional right has been violated.
In criminal or in civil?
Oh, in criminal, yeah.
Okay, I'm going to explain that. I'm going to explain that in a minute. All right, so give me a minute. All right, so we are all clear. If we are all clear in terms of how you bring this judicial review application, how you bring this judicial review, how you approach the court, then give me a thumbs up. I've said that various settings. Okay, if the examiner can tell you, hey, go and seek leave, so that is you seeking leave. The examiner can say, leave has been sought. Prepare the substantive document. You prepare the notice of motion. The examiner can tell you, prepare the application. Then you prepare the application, which is the leave document and the substantive stage. Or the examiner can tell you, prepare the pleadings, which now includes an option of doing a petition. That is clear. That is clear. Now, when do you do a petition specifically? If the question say prepare the pleading, but also if from the question you are seeking more than just the 3 orders of judicial review. If you want declaration of right, if you want conservatory orders, if you want damages, compensation, then you need to go through a petition. When you go through a judicial review application, you can only get the 3 orders of judicial review, that is mandamus, prohibition, or certiorari. So that is clear. That is clear. Now, whose decision can you challenge through judicial review in criminal? Now, I've said, guys, the criminal administrative institutions. Number 1, the DCI, the AG, the DPP, the ESCC, the Inspector General of Police, the Inspector of Police. We have the NCIC, the Ministry of Defense, or the Department of Defense, the DoD. So anybody, any institution that makes a decision that would implicate you criminally, that would be a question that would be ripe for judicial review. It is an administrative decision, therefore it must be reviewed. Most of the time in criminal, it is usually about a charge, that they have decided to charge you, or they have decided to do something, maybe freeze your accounts or whatever. Okay, so anytime the police is acting in their criminal jurisdiction mandate, then that decision would be subject to judicial review. You cannot challenge a court decision through judicial review. If the court has made an order, you either revise it, you appeal it. Are you together? Revision, appeal, or in certain circumstances under Article 56, you can always apply for a trial, but you cannot have judicial review against the decision of court. So the DCI, the AG, the DPP, the ESCC, the Inspector General of Police, the NCIC, the Ministry of Defense, or the Department of Defense, those are criminal administrative institutions. Therefore, their decisions would affect you criminally, and their decision is usually one. All the bodies that I've mentioned, they usually make one decision, which is one decision, a decision to charge, or a decision to bring charges. They would sit, the DCI would sit and say, you are guilty of this offense. We are going to charge you. We are going to arrest you and charge you. Okay? The ESCC will say, you are a corrupt person. We are recommending that the DPP to charge you. The DPP will decide to charge you. So it is usually about you being accused of an offense. That decision is usually one, that you be accused of an offense, or some of your assets be frozen, So most of the time, it is about the decision that is made by these criminal institutions that will impact your life differently. And therefore, that decision, you will bring it before the High Court and you tell the High Court that, Your Honor, this decision is affecting my Article 47, the right to a fair administrative action, and I would want it to be quashed. So that is whose decision. That is the question of what can you do? For instance, what can you do? So let us read the question, and then I can answer the question that I want us to answer, which is the what, when, where. Somebody read the question if you can see it.
Medellin is a multinational company run by a Colombian family with Escobar, Padrino, and Alberto as the directors. The company has many business concerns, including print and media. In 2019, Kenya School of International Law advertised a 5-year tender for supply of quick response code readers and stickers to be used by students as they access the school. Medellin, through its Kenyan subsidiary, successfully bid for the tender. It was awarded the tender partly because it had supplied similar services to other government institutions. In April 2020, students raised complaints that they were unable to access the school since the machines installed by Medellin were faulty. After internal investigation by Kenya School of International Law, it was discovered that some employees of the school had colluded with Madeleine's local directors and diverted the authentic machines for 50 million shillings kickback by another company in South Sudan. The matter was referred to the Directorate of Criminal Investigations, and after investigation were carried out, the DCI detectives arrested some of Kenyan School of International Law's employees and some of the students who had raised concern on social media. Charges were preferred against some of the employees of Kenya School of International Law, as well as the directors of Medellin, Escobar, Padrino, and Alberto. The charges were filed at Milimani Law Courts, and the Chief Magistrate issued a warrant of arrest against the 3 directors who are said to be in Colombia, yet they have never been questioned by the DCI. The directors of Madeleine's local subsidiary were nowhere to be found, and charges were not preferred against them, and no reason was given for this. You have been approached by the directors of Medellin, who inform you that Alberto is 78 years and cannot travel to Kenya. Padrino also resigned from the company 3 years ago. Escobar takes care of Alberto on a daily basis. They also explain that they consider the decision to charge them irrational and an abuse of power by the DCI. They insist that they did not have anything to do with the disappearance of the machines at the Kenya School of International Law. They have instructed you to represent them, indicating that they do not want to come to Kenya for trial. Draft the appropriate pleadings.
Yes, draft the appropriate pleadings. What would the appropriate pleadings be in the circumstance in question? Now, the question really is, they are challenging the decision of the DCI. And let me make it clear again. Anytime you're challenging the decision of a DCI, anytime you're challenging the decision of the DCI, the EACC, the DPP, anytime, guys, let me make it simple for everybody that is involved. Anytime, okay? Guys, are we together?
Yes, we are.
Yes, Mwalimu.
All right. I'm trying to It's buffering. But anyway, I was saying that anytime you are not agreeing with the decision of a body that is the bodies that I've mentioned, it is judicial review. Let me make it clear for you in criminal. Guys, anytime you are challenging a decision of a court, appeals, revision, or retrial, full stop. Anytime you are challenging a decision of any other person who is not a court, judicial review. So that is supposed to be very clear. So if you read this question, whose decision are they challenging? They are challenging a decision of the DCI, okay? The DCI, who have decided after their investigation that they want to charge your client. They have decided that after they have done a proper investigation, whichever investigation that they have done, they think they want to charge your client. And from the story, you can see that your clients have not even been questioned. They're not in Kenya. The people that were supposed to be arrested, which are now the Kenyan, and the Kenyan directors, have not been have not been arrested. They're not being questioned. But the people that are supposed to be charged are these directors that are in Colombia, for instance. So they are challenging a decision of the DCI. And in that instance, it is judicial review. Okay? Judicial review. And that will apply also in criminal, guys. Sorry, in civil. Anytime in civil, you are challenging a decision of an institution. Okay? Normally, it is through either judicial review or through a petition. Okay? Judicial review or a petition, except in the instance where you're bringing a plaint. In the normal instances, a suit for something that they've done, a condition. But if you are challenging a decision that has been made, which is administrative, you proceed and do judicial review. So in criminal, it is a clear-cut thing. We don't have plaints in criminal. We don't have statement of claims. We don't have originating summons. We only have two things: the petition and the judicial review. So you bring a judicial review if you are challenging a decision of any institution within the criminal justice system. But if it is a decision that is made by the court, then you can only review it. You can only review, which is a revision. You can appeal it, or you can apply for a trial. That is clear. If it is clear, give me a thumbs up. If that is clear, thumbs are supposed to be up. Eunice, what is your question?
No, it's not a question. I was giving my thumbs up, then I clicked on the wrong emoji.
Are you saying your thumbs are big?
Yes, they are.
Okay. Hey. Okay. Let me click on your name again and see if this person is that. Yeah. Okay. So that is that. So I've made it clear for everybody that in any instance you're challenging a decision that is not of a court, anytime in criminal you are challenging a decision of someone who is not of a court, then you proceed and do judicial review. Now, that is the question. So what are they supposed to do? They need to go to court for an order of judicial review. How are they going to do that? In this instance, the easiest to do is to do a petition and the supporting affidavit. But you could decide to do the 5 documents. You still get your marks, but you will lose a lot of time. So in this instance, just do a petition, and then within your prayers in the petition, you pray for orders of judicial review. Okay, for instance, a judicial review order of, a judicial review order of mandamus. Let's start with certiorari, quashing the decision of the DCI to prefer charges against the applicants, the first applicant, the second applicant, and then the third applicant. Okay, and then you pray for an order of, let's say, do we need a mandamus here? Yes, you're going to need a mandamus here, but that will be the last order. You pray for an order of prohibition prohibiting the DCI or even the DPP from preferring charges against the three clans. And then, guys, the mandamus order will be directed to courts. Let me tell you how that will happen. Here. Sorry. Let me highlight that. That is why you're going to get orders of mandamus. Okay? The charges were filed at Milimani Law Courts, and the chief magistrate issued a warrant of arrest against the three directors who were said to be in Colombia, yet they have never been questioned by the DCI. Now, these charges are already in court. Okay? So your clients are the applicants. Okay? Your clients are the applicants. Your second your first respondent, the respondents will be three in this instance. We have the DCI, we have the DPP, and then we have the court. That is the chief magistrate court in Milimani. Okay, so we have the Milimani chief magistrate court. That is your third respondent. However, you are not suing the magistrate. You're not suing them. They are a party to this case because the charges that we are trying to challenge are before them. So you get an order of certiorari quashing the decision of the DCI and the decision of the DPP. You get an order of prohibition prohibiting the DCI and the DPP from continuing or from bringing any further charges against your clients. And then thirdly, you are going to pray for an order of mandamus compelling the chief magistrate to remove that file, to vacate the proceedings before it. Because remember, guys, once you quash the charges, there is no proceedings before the court. They're already filed. And because they've already been filed, they have to be removed from court. For you to remove them from court, the court must be directed to remove them. And therefore, you ask the court to give an order of mandamus directing the chief magistrate in Milimani to remove the proceedings from it. Okay? To remove the proceedings or to vacate the proceedings and to further not entertain that proceedings. In this instance, guys, we are not challenging the decision of the court. We are not saying the court has made a bad order. No, we are just telling the court that that matter you are proceeding with, please vacate it. Please stop entertaining it. That is an order of mandamus. I hope you're getting what I'm saying. But if this question did not mention any court, then you'll have just the orders that we have mentioned, the orders of judicial review against the respondents in this case, which are the DCI and the DPP. Guys, are we together? So you only bring the court as a party if the charges have been filed before that court. And why? Because you want to remove the file before the court. That is why we have orders of judicial review directed to the court. They are not challenging an order of the court. The court has not made any order yet. We are simply saying that please remove the charges before you. Guys, are we together? All right.
Yes, Mwalimu.
All right. Sawa. So that is how you frame your parties there. So if it is a petition, your first petitioner is going to be maybe Padrino, and then Alberto and Escobar. Okay, those are your first petitioners. And then you're going to have your respondent being the DPP, the first respondent. The second respondent is the DCI, and then the third respondent being the chief magistrate, Milimani Law Courts, as the third respondent. If it was an application, then the applicants are your clients. The respondents would be the DCI, the DPP, and the magistrate court. But remember, that is in the leave stage. Okay, in the substantive stage, Now we are going to have the Republic versus the DCI, the DPP, and the Chief Magistrate. And then we are going to have your clients, the three of them, becoming ex parte applicants. The first ex parte applicant, second ex parte applicant, third ex parte applicant in the substantive stage. Guys, I hope we are getting together. So the question is when? When do you make this application? Any application for judicial review is made from what time? Now, you can only bring a judicial review application against the decision of the DPP or any institution after they have made the decision. So anytime after the DPP has decided to charge you, you will bring a JR proceedings against that decision. Up to what time? From the time they've made the decision. Remember, the file is prepared, the file is taken to the DPP decides to charge. From that specific moment, you bring a judicial review proceeding. Okay? Either within the application or within the petition. Up to what time? That specific application can only be entertained until Section 210, a case to answer, where the court has made an order that there is a case to answer, you cannot bring judicial review anymore. So you can bring it anytime. You've been charged, you can bring it. You've taken plea, you can bring it. You have been given bail, you can bring it. You go for pretrial, you can bring it. Hearing stage, you can hearing. I mean, the prosecution's case, you can bring it. And then if the court finds there's a case to answer, you lose the right to bring judicial review. Because that means, because what is judicial review? Judicial review is, you are saying these charges are not clear. These charges are trumped up charges. They are fake charges. There's no case here. They're trying to hunt me. They're trying to kill my political ambitions. And then the court will go through that. And then the court will make a ruling under Section 210 that there's a case to answer. What is that? What does that mean? That means the court has gone through the file and the court is saying, actually, this is not trumped up charges. There is a case here. And for that reason, you will lose the right to bring judicial review. So judicial review is brought at any point before the court finds a case to answer. Okay, before the court finds a case to answer. Are you together? Or before judgment. Before judgment is passed, but it is normally before the ruling. So that means, therefore, after the ruling or after the case to answer, you can only challenge that as a court order. That is a court order now. You can only challenge it through revision, appeals, or retrial, depending on the circumstance. That is the end of judicial review. Any question? I am happy to answer questions. Joy?
Thank you. So even if it's before judgment, that means it could still be, it can either still be the application or the petition or supporting affidavit. It can be any.
Come
I'll
again?
just let you know the difference. When we're talking about what to file, like for the JR, we could still, you can use any of the processes. Can you use petition, supporting affidavit, or the ones that on all the 5 documents or leave stage? When is it appropriate to use the different ones? I think that's my question.
The different what?
When is it appropriate to use petition and supporting affidavit or to go via leave stage?
But that is what I've explained in this entire class.
Okay, I guess then I'm not going to too
That is
clearly.
exactly what I've said from the very first time I mentioned judicial review up to the last thing I've said right now. That is all about it. Somebody answer that question quickly. What did I say? Jamal, answer the question.
Yes. Okay. Yes, I wanted to answer the question. Okay. To the person who has just asked, what Jackson said, there are two approaches that you can follow when you're answering this question. You can either go through the petition process, which is easier and shorter. It saves time. So in that case, when you want to challenge a decision, like the one that is here, a decision to charge, you can use a petition and seek some of the orders of provided under Article 23(3), that is the orders of certiorari, mandamus, and the other JR orders that are available, but through a petition. The alternative way of also challenging the same decision, the same administrative decision, you can now go through the JR application, which is now through the leave stage and the substantive stage, where you will now draft the 5 documents, both the chamber summons when you're seeking leave, with the now notice of motion in the substantive stage. That was my understanding of what Jackson explained.
Okay, so guys, I've said this, and I'll say it again. There are 2 ways of going through judicial review. The first way of going through judicial review is a pleading. Okay, the first way of going through judicial review is through a pleading, which is this pleading is normally a petition, but also there are certain instances where the miscellaneous application is treated as a pleading. Okay, that is the first one. So if the question say draft a pleading or draft the necessary documents, and the examiner does not specify which one, then the question is open. You can decide to do the petition itself and ask for orders of judicial review in the petition, or you can go through the 5 documents. Okay, which will of course eat your time. That is the first one. Joy, are we clear up there? I can't hear what you're saying.
Yes.
The second one is where the examiner say, where the examiner said, draft the application. Okay, 2019 question 1. If you have that question, please, you can forward it to me. I can project it. 2019 question 1, draft the application. It is the same as this one. The facts are different, but the same as this one. The question says draft the application. Now, in this instance, it is an application. It can't be a pleading. And therefore, in that instance, you draft a notice of motion, the judicial review application, which will include all the 5 documents. Thirdly, the examiner can say, proceed and seek leave. Now, that instance, you cannot draft all the 5. You can't draft a petition. You can only draft the leave stage, which is the 4 documents. Okay? And then sometimes the examiner can say, leave has already been sought. Proceed and draft the substantive document. It means you don't seek leave. Leave is already there. Proceed and draft the notice of motion and the supporting affidavit. So those are the dynamics when it comes to setting a question on GIR. Are we together?
Much clearer. Thank you.
All right, any other question? All right. Now, what are the JR documents, guys? I really don't think we need to go through them one by one, unless you guys think we should, which I don't think we should because of time. If you did ask me, what are the 5 JR documents? So we are going to go through them in passing. So, certificate of urgency. So we are going to try and figure out what we are going to draft in this question. Certificate of urgency. What do you have under certificate of urgency? What do you have under certificate of urgency? What do you have under certificate of urgency? Uh-huh. All right. So what are the 5 documents? Petition is clear, so we don't need to go through that. Petition is clear, unless somebody feels like we need to go through that. We shall go through that if somebody feels like we should. But what do you have under certificate of urgency? Just indicate that I, Boniface Anyona, an advocate of the High Court of Kenya, do certify this matter as urgent for the following reasons. Now, in our case, that the DCI have preferred charges against the applicants. So the last paragraph is what is going to be forming part of your certificate of urgency. So this is where the certificate of urgency is. This, okay? This and this. See, everything I've highlighted, that is where the certificate of urgency is going to capture. That the DCI have charged the applicants in the Milimani Law Courts, and the Chief Magistrate has issued a warrant of arrest against the three directors who are in Colombia and are yet to be questioned by the DCI. In fact, give me a minute. Just leave it there. Certificate of urgency is not marked, guys. We are not marking the content of certificate of urgency. No, unless you draft your own things. Certificate of urgency is not marked. So what I'm saying not marked is we're not looking at the content of the certificate of urgency. So therefore, don't waste your time trying to write anything that is not important. Just say, why do you want to certify this matter as urgent? Because the DCI or the respondents have filed a case or have filed charges before Milimani Law Court, and the Chief Magistrate has issued a warrant of arrest against the applicants who are in Colombia and have never been questioned by the respondents. Full stop. You have given us the reason why you think it is urgent. And then we go to our next document, which is a chamber summon application. The chamber summon application is supposed to contain 2 things. Number 1, supposed to contain your prayers and supposed to contain your grounds. Okay? Supposed to contain your prayers and supposed to contain your grounds. What are you going to indicate? Let all parties concerned convene before the judge. This is before the High Court, the judge in chambers on the dash day. Don't write the date. On the dash day of dash 2024, where the counsel for the applicant at 9 a.m. or before noon or soon thereafter, where the counsel for the applicant shall be heard on his prayers for or on his application, shall be heard on his application for orders that number 1, number 2, number 3, number 4. So what are the prayers? What are the prayers? The first prayer is that the application be certified as urgent and service be dispensed with in the first instance. 1. Number 2, this is an application for leave stage. So you are going to pray for leave, that the court do grant the applicant leave to seek judicial review order of mandamus. Leave to seek judicial review order of certiorari. Leave. I don't know whether we are getting to the point where I want us to get to. So this is application for leave. So you have to pray for leave. You are just praying for leave to seek, leave to apply, leave to apply, leave to apply. So first one, the application be certified as urgent. Number 2, leave. You don't have to say that the court do issue. If you don't have time, just say leave to apply for a judicial review order of mandamus to do what? Leave to apply for a judicial review order of certiorari to do what? Leave to apply for judicial review order of certiorari to, I'm sorry, prohibition to do what? And then cost. Okay? So guys, make sure you understand. So leave, it is an application for leave. So leave must always appear in each and every prayer. And then you go to your grounds. The grounds are in the question. Just summarize. Okay? Just summarize. What are we summarizing? We are summarizing the facts. Just summarize the facts under your grounds. Okay? Just summarize the facts under your ground. And you don't have to go through the facts. Okay? You just need, even let me just highlight that for you. Just that part is enough to capture your ground. Just summarize a few grounds, just 2-3 paragraphs. You're done. Drawn and filed by to be served upon, and then you go to your statutory statement. What do you need to have under the statutory statement? 3 things. The first one is the name and description of the applicants. Name and description of the applicant. So you will give us the first applicant is maybe Escobar, the second is Padrino, and then the third one is Alberto. Name and description of the applicants and their address of service, which will be your address as an advocate who is preparing. Okay? And then, so for instance, you'll be saying that the first applicant is a male adult of sound mind, a citizen of Colombia, whose address for purposes of this suit shall be your address as the advocate. The same thing for the second and the third. And then you are going to give us the second part of your statutory statement, which will be the reliefs that you're seeking. What are the reliefs that you're seeking? So you are seeking, now these are not, you are not praying for leave now. You are seeking the main reliefs. What are the main reliefs you're seeking now? You don't say leave, main reliefs. So what are the main reliefs you're seeking? That judicial review order of certiorari to do this, judicial review orders of mandamus to do this, judicial review order of certiorari to do this. Full stop. C, grounds. What grounds are you relying on? Copy paste the same grounds you had in your supporting of, in your chamber summon and put them there. So the statutory statement will have the 3 things. The A, B, C. Part A, name and description of the applicant. Part 2, relief sought. Part 3, the what you call the grounds you are relying on. So the grounds. And then you go to your verifying affidavit. Now, what is going to be in the verifying affidavit? The entire facts. The facts will be in the affidavit. All the facts will be in the affidavit. In fact, when you're doing a verifying affidavit, you can just copy paste that specific question word for word, okay, word for word, until the point that I've highlighted last. So you only leave, they have instructed you to represent them. Don't copy paste that one. I know some of you are very crazy. Somebody can just copy paste until they say they have instructed you to represent them, indicating that they don't want to come to Kenya. Draft the appropriate pleadings until they write 10 marks. And then you're like, this person was possessed. The demon was very strong in this man. So don't copy paste everything. Just write the facts, just the story. So essentially, narrate for us the story in the question. Give us the story. So report the story. That is all. You are done with the leave stage. You're done with the leave stage. Are we together? So if you are supposed to go to the substantive stage, then of course you know what is going to change. There are 2 things going to change. The first thing going to change are the parties, where we are going to have the Republic now as the applicant. The respondents will remain the same. The respondents will remain the same. The respondent will always remain the same. The applicant will change. And then after the respondents, we'll have ex parte applicants. So Alberto, first ex parte applicant, Padrino, second ex parte applicant, and Escobar, the third ex parte applicant. That is the first thing that will change. The next thing that will change are the prayers. you're going to have the same prayers you had in the chamber sermon, but you're not going to indicate the word leave because you've been given leave. Now you're going to indicate, take notice that this honorable court shall be moved on the dash day of dash 2024 at 9 a.m. or before noon or soon thereafter, where the counsel for the applicant shall be heard on his application for orders that. What is the first order? Number one, a judicial review order of mandamus doing this, a judicial review order of certiorari doing this, a judicial review order of prohibition doing this, an order of cost. And then you go to which application is supported or is based on the following grounds. Same grounds that you've had from chamber sermon until now. You just copy paste the same. And then you proceed and close by saying which application. So if you're doing the substantive stage alone, you need to do notice of motion and supporting affidavit. But if you're doing an entire process from leave stage, you don't have a supporting affidavit for the substantive stage. Lastly is something I want to mention, that when you pray for orders of judicial review, it doesn't mean I've said you only get the 3, but it doesn't mean you need to have 3 prayers. I have said when you pray for judicial review orders through, let's say the application, you can only get 3 orders of judicial review, which is mandamus, certiorari, and prohibition. It doesn't mean you pray for 3. Okay, you can only get 3 orders in that nature. So that means you can pray for 10 prohibitions. You can pray for 20 mandamuses. You can pray for 30 certioraries. So you can pray for even 1 million prayers, but so long as those prayers are within mandamus, certiorari, and prohibition. Or you can pray for 5 certioraries only. So I'm not saying you must have 3 prayers only. No, you can have as many prayers as possible, but the nature of those prayers must only be restricted to mandamus, certiorari, and prohibition. For instance, if you look at the question and you think there are 2 things to be quashed. For instance, you want to quash the decision to charge, and then you're also quashing the warrant of arrest given by the court, then those are two certioraries. If you want to prohibit the DCI from doing 2 things, those are 2 prohibitions. So what I'm saying is, look at the question and ask yourself, what am I challenging? Certiorari to do what? Mandamus to do what? Prohibition to do what? And then you line your prayers. Guys, that is the end of judicial review. That is the end of the specialized courts. I am happy to take a question that is needed if there be a need. Anything? Guys? All right, we are together. Guys, ask any question that you have. We are done with the. So questions that you have in criminal, not just judicial review. Joy?
Yeah, Malemu, it's just a request, or it's a request and not a question. If you could please share past papers for criminal litigation. Of course, we have a few, but just in case we don't have a few, then if you have them, if you could please share them on the group. Thank you.
That has been shared in the group all the time. People have those links in the group there. Somebody will share those links in the group on the past papers. But trust me, you don't need to look at all the past papers. If I were you, I would not look for any paper that is after 2019, before 2019. I will not look at them. Even in our class, you've seen I've only restricted myself to 2021 to 2024. Yeah. So, like I'm saying, you don't need to look at all the past papers. Yes, you need to look at the past papers, of course, to familiarize yourself, but you don't need to look at all the past papers. They will never repeat a question verbatim, but whatever they have said before, they will say it again, but in a different way. So yes, you look at the past papers, but again, instead of going to 2014, somebody is sitting down and revising a paper in 2014, don't look at that paper. Things have changed. The curriculum has changed, I don't know, 3 times since 2014. Right now, we are looking at a new system. So the new system came in 2020. 2019, we have a different mode of setting in 2021, June, coming all the way 2024. So look at all the papers from 2021, 2024. If you're done, look at 2019 and then keep revising. Okay, so don't worry about whether you've looked at all the papers. No, don't worry about that. Everything that has been set before will still be set, but of course not verbatim as you'd see in those instances. But just like, for instance, the question in 2019 question 1 is the same thing as the question you are seeing on your screen, but the facts are different. It's the same thing, but the facts are different. In fact, all judicial review questions are set the same way. 2019, there's a question in 2022 as well, set the same way, just different facts. Okay, so yes, somebody share those past paper links in the group, and then everybody can access them there. And anything that you have, share them. Any other question, guys? All right, no questions. So I'll see you guys for civil in the evening. Please, I will stop sharing the screen. We will start now the marathon for criminal in, tomorrow in the evening at 8. If possible, we can start by 7. I don't know whether that is possible. I would love to start early though, but sawa. So I will see you guys for civil in the evening, and then conversing tomorrow same time, and then criminal at 8. And then on Wednesday, we are going to have civil at 11, civil at 2, civil at 7. And then that shall be our structure for the week. Guys, bye. Take care of yourself. Please ask for this recording right now. Please ask for this recording right now.
Thank you, Mwalimu.
All right. Thank you. Bye.